SJC-12571, Commonwealth v. Brandyn, S. LePage.
Okay, Attorney Wood.
Thank you very much, and thank you to the clerk for accommodating us and letting us go first. My name is Chauncey Wood. I represent the appellant, Brandyn LePage. I want to begin by moving straight to the central factual dispute here, what I think is going to be most important to the court. Whether Fall River police officer Steve Washington lied or acted in bad faith to T-Mobile in the exigent circumstances request form he'd submitted to obtain Mr. LePage's cell phone records. On October 1st, 2012, at about 3 p.m., Detective Washington sent an exigent circumstances request form to T-Mobile requesting Mr. LePage's call detail records, or CDRs. That was more than 48 hours after the killing at issue here, which occurred on September 29th, 2012, at about 1:20. The T-Mobile exigent circumstance request form defines exigent circumstances as, quote, immediate danger of death or serious physical injury to any person.
Wood, can you distinguish between legal sufficiency for that exigency, which we can talk about with reference to our prior case law, Chamberlain, I think is the case, versus what Judge Dupuy found on credibility issues, where you say she's clearly erroneous? Because I think they're two distinct parts of your argument. So if you could address how she was wrong first, and then we could talk about legal sufficiency after that.
Yes, so I think I agree with that. And I think that I am trying to go right to the factual issue of whether there were, and I think we're on the same page here.
The first issue, the
right.
sufficiency issue.
Right.
Okay.
I believe she was clearly erroneous. Well, it was. I think there's a subsidiary question, though, I think, and I'm not trying to dodge. I think it's in order to determine whether her finding was clearly erroneous, whether there were exigent circumstances, we need to determine, I think, first, whether we agree that Detective Washington's statements were false, intentional, or in reckless bad faith. And so I think that's the crucial foundational question, and that's what I'm addressing, if that is acceptable. Please. Okay, so he wrote on the form, quote, homicide investigation and number, parentheses, phone, parentheses, was last contacted during murder, unknown where owner is or if owner is alive or deceased. So first I note that this assertion included several false statements that were either intentional or reckless, amounting to bad faith. And so first, I'll focus on two of them. Washington asserts that the victim was on the phone with the subscriber at the time of her death. Quote, last contacted during murder.
Wait, does he say that?
He says so.
Well, use his words and rather than reformulate them.
Yep, I will. Homicide investigation, I'm quoting now. Homicide investigation and number, phone, was last contacted during murder. So that's last contacted during murder. I submit that the only reasonable interpretation of what he's getting at there is that he was on the phone with the victim at the time of her death.
Well,
last contacted.
That's was last contacted during the murder. So she's murdered at 1:23 or something like that.
About that.
And the phone is last used at 1:10.
Yes, but her last call to Mr. LePage is 10 minutes before that.
Again,
yes.
Yeah, so the phone is no longer used after the murder, right? And
yeah.
So the last time the phone's used is a couple of minutes before the murder. So is that really an inaccurate factual statement?
I think, well,
it could be more precise, but to accuse him of, lying is, that's significant. So I just want you to be careful. Go ahead. Mm-hmm.
So I think that it's at least reckless and in bad faith. And again, the context here is demonstrating exigency to get somebody else's private phone records. And he's saying last used during murder. It's our position that
let's push that again.
Sure.
So
the other...
he's not using the phone as the murder weapon.
Right.
So last used during the murder is a sort of, incomplete, but not particularly descriptive, but to find it a lie, I don't know. You just seem like you're pushing it way over. You're going what he's doing. You're overstating what he's saying.
Well, I respectfully disagree, but let me move on to the next point. And I take your point, and I will come back to it, but that it's at best an exaggerate. It might be entitled a slightly careless or incautious exaggeration.
Like what you're doing, overstating it. Go
I
ahead.
mean, I'm quoting the language. To be perfectly candid, as an officer of the court, I'm quoting the language. Last used during murder. I was an English major. During has a specific meaning. And I submit that during means at the time of the murder, not 20 minutes before the murder. So with all due respect, I think I'm not overstating. But I understand your point, and I'll come back to it. So secondly, Detective Washington claimed that he didn't know whether LePage was alive. I'll quote the language. Unknown where owner is or if owner is alive or deceased. Now that was just not true.
We know he knows LePage is alive? Mm-hmm. How do we know he knows?
Because he got the decedent's phone records. He found this phone number, which was Mr. LePage's. He called it 3 times. And each time, the person, the owner, answered the phone. Brandon said, "I'm Brandon Jackson." And he says, "Come in. Can you come in and talk to us?" "No, I'm in New Bedford with my mother."
So at least with regard to that last statement, arguably you could say you didn't know where LePage was because he had misidentified himself as Jackson, right?
Well, so yes, I think that's right. You don't know 100% it's Brandon LePage because he's saying Brandon Jackson, and he says, "I'm in New Bedford," but you don't know for sure that he's telling the truth, that he's really in New Bedford. So it's fair to say, I think it's fair to say we don't know where he is.
Right.
But I think it's less fair to say that you don't know that that the owner of the phone is alive.
Isn't it more like whether there's an agency where there's a murder, this is the last contact, right, before the murder, and there's a killer on the roam, essentially. That's, I think, what it boils down to.
Well, so the next thing that that's correct. It's the immediacy. I think I agree mostly. It's the immediacy. So what I'm trying to get to is the most important thing here is actually an omission in this claim. What he doesn't say is that the killing occurred more than 48 hours earlier on September 29th at about 1:20 p.m. So what I'm saying, I agree with you.
Isn't there still an agency where there's someone that's killing drug dealers?
So
there?
the answer I submit.
And I know Chamberlain had some issue, or maybe it's Chamberlain, you'll correct me, but it had some issue about whether there's a sawed-off shotgun, which to me is neither here nor there. It's still.
So the question. Sorry, I'm sorry. I didn't
No,
mean to cut you off.
please answer that.
So Almanor, I think, is the most relevant case. And so I think that Almanor quite explicitly addresses the relevance of temporal proximity. And so I would quote the relevant language in Almanor. It says, the court considered there whether, quote, the circumstances that led to the shooting had dissipated. Okay, that's from Almanor, this court's decision in Almanor. I think that Your Honor is absolutely right that the essence of exigency is an immediate threat to the public safety. And I take your point that what are you talking about? Not a threat. You got a guy who's just killed somebody and he's on the loose. A killer on the loose. That's what we all get. Right. The problem is that's not what the case law says. The case law says that it's the immediacy of the threat. And more than that, Almanor focuses on other factors. Why is this person just a crazed killer out killing anybody? Or is there a reason for this particular killing that the police know? And in this case, the police did know that this was almost certainly a drug-related killing because it was known that the decedent was a drug dealer. It was known that her pockets had been turned out. It was known that she had crack cocaine on her. And she was in her own car. Killed from the right-hand side, so somebody in the car, which supports an inference that there was a drug deal gone bad. So the police knew all of that. And so my position is that both the lack of temporal proximity and the fact that the police knew that this was a specific killing, they knew the motive and the reason for this killing, that there was a dispute between dealer and seller, and therefore this killer on the loose was not likely to go kill any random person, but rather had a specific dispute. At least that's our position. So our position is that for 2 reasons at least, this fails to establish exigency. And then in light of that important omission, and so again, the exigent circumstance request form did not include any of that. the circumstances of the killing.
And correct me if I'm wrong, so Judge Dupree's findings more had to do with whether or not this was really a CSLI ping issue, which is a separate issue than your exigency issue.
Right. So to get to to answer your question, what did Judge Dupree find that had to do with this?
Right.
Right. She found that Detective Washington wasn't lying or wasn't acting in bad faith, to Justice Kafker's point. Okay. Well, what's that based on? So first of all, he wasn't lying. The easiest way to answer that is, sorry.
To your point, though, we have to look to see what even if we find that there's no omission, we need to find the legal sufficiency of that representation, whether it matches our exigency case law, essentially.
Yes, I agree with that. So just to finish the point and then move on to that, she is looking at the evidence she has in front of her that he wasn't lying or acting in bad faith is from the evidentiary hearing on our new trial motion. And we very clearly lay out that all he said there was, I don't remember. I don't remember what I said. I showed him the document. What did you mean? I don't know what I meant. You really don't know? I can't remember. So my point very simply is she could not make a finding that he wasn't lying or acting in bad faith based on that testimony because he didn't remember. So all we have is the undisputed factual record, what he wrote and what he didn't write on that exigent circumstance request form. So that's the facts. So moving to the law, I think your next question. So I think so.
Can I
Yeah,
push
sure.
one last point on that?
Yes.
So Augustine hasn't been decided at this point, right? So
Yes.
you don't, we're sort of in an earlier world where you just kind of file these things and you get, it's not clear that he's getting around, an Augustine problem, right? He doesn't have. I think the judge says he doesn't have an incentive to sort of lie, right?
I think that's absolutely fair point. The question you're getting at is, why would he lie? He could have said honestly, like, I just want these records. What I'm getting at, what I'm suggesting is, I don't have an answer. Well, candidly, I don't have an answer to that question.
By the way, it's before Almanor too, right?
Yes.
Yes.
Right. So I don't have an answer to the question, why did why would he need to lie? If you're disputing whether he lied or acted in bad faith, but the motive question, why did he need to? For one thing, the form said you need to demonstrate exigent circumstances. So regardless if he felt he needed them, but then why did he, after the fact, try to cover that up? I don't have an answer for that, except that my best guess is that the police didn't want to disclose their investigative techniques. But in any event, it doesn't matter.
Where does the law lead us? Assuming we agree with you, where does the law lead us when we're dealing with call logs?
Yeah.
And I know the Vinnie case. This is really just a D order administrative subpoena in that era.
Yeah.
Where you really didn't have to show exigency. You just said, hey, I'm a police officer. This is a D order.
Right.
Give me just the call logs, which aren't really protected, as Augustine's Gantz concurrence says, and a lot of cases say.
Right.
So where are we with call logs?
Yes. So I think that it's a new concept. I'm asking the court to make new law, to be clear. And I lay this out most clearly in my reply brief at page 11, and I cite the case law. The concept, which this court hasn't yet recognized, is a reasonable expectation of privacy by law. And it's actually...
But we've said differently with respect to call logs.
So here's that's the Gumkowski case,
right?
And and I address that case. I distinguish it at pages 11 and 12 of my reply brief. And specifically, the SJC clearly did not address the question here in Gumkowski. In Gumkowski, like this case, there was an exact same request under the SCA for SCLI call detail records, which include CSLI and call logs. They alleged exigent circumstances, and all of it was produced. The defendant, crucially, did not allege that the representation by the police was false, that there was a false claim of exigent circumstances. He made a different argument, that the call logs were fruit of the CSLI. And the court said, no. Those are the call logs are not fruit of the CSLI. They're separate. And so there was no dispute that if the court rejected that, Gumkowski loses. There was no question of what do you do? What's the significance of a police lie? There was no allegation of a police lie.
But it's a statutory violation like
right.
Vinnie.
Yes, that's right. That's right. And so what I submit, and this is new, relatively new law.
If we agree with you, it's a statutory.
That's right. It's a federal statutory. I'm relying on the federal statutory violation. In a nutshell, the concept of reasonable expectation of privacy by law is that statutory violation creates, or that statutory requirement of exigent circumstances, which is what the SCA requires, creates in turn a reasonable expectation of privacy in your call logs, something that previously has not been recognized by this court.
But our case law, and I'm just remembering the Gantz concurrence in Augustine, which basically says, come on, call logs, that's something that's given all the time. I mean, we're not a third-party doctrine, but maybe we are, right, as far as call logs go, because everyone knows when they pick up the phone and they dial a bunch of digits. That's not really protected.
So the world
versus location,
yeah,
et cetera, et cetera.
Again, I'm trying to be candid. I'm being candid here. I'm asking the court to establish new law. But I asked the court to look carefully at the case law I cited. I'm not painting on a blank canvas here. Most relevantly, in People v. Seymour, just last year, Colorado case, not binding on this court, the court said the society is ready, meaning it's new, ready to recognize a right of privacy in call logs. And so, but beyond, and so.
That is SCA violation case, or was it Colorado?
I don't know.
Administrative subpoena, you don't know?
I don't know the answer. I'm happy to submit.
What about federal case law on violations of section of D orders?
So do you mean the SCA specifically or anything else?
I'm used to call them D orders because it's not, but anyway.
I don't know the answer to that question. I'm happy to submit a post-argument letter about that, but I don't know the answer to that. But a great analogy is another case that I cited here. So first of all, the concept of reasonable expectation of privacy by law is recognized by the Supreme Court in Rakes v. Illinois. So then the question is, I think, and a fair and important question, what do you do when the police lie to get something pursuant to a statute? Isn't that something that's, and does it, and you're asking, well, okay, what are they lying, what are they trying to get?
Right, I guess the point I'm asking you about is if we don't agree with you the police lied, but we think that agency wasn't satisfied, as you've argued. Say we agree with you on Part B, not Part A. Where does that lead us as far as a violation goes? I know where you want us to lead, but where does that lead as far as a Vinnie violation goes on a statutory violation, as far as a remedy, I guess?
Okay, so I mean, that's a tough question for me because I have never thought of it that way. I think that it's crucial, it's important. I think it's important that if police lie to get a person's personal information, and that's what your call logs are. It's important to understand, especially in the modern age.
So suppose the hypothetical I have.
Right, they didn't lie.
They didn't lie.
And they didn't act in bad faith.
But they were.
It
didn't satisfy exigency.
I mean, to be candid, the point of the thing doing the work here is deterrence. We don't want the police to lie. That's the whole principle of the Fourth Amendment is deterrence. And Article 14, of course, is what I'm asking you to apply. But I think that's a fair question. But what I'm really hanging my hat on is deterrence. We don't want the police to lie. Now, I think it's clear as day.
What is the remedy for the federal statutory violation if it's not a constitutional violation?
In the federal context, you have civil rights. You're suing the phone carrier.
The carrier and the cop, or just the carrier?
I know for sure you have the carrier has liability. I'm not aware of any. I mean, maybe some creative lawyer could come up with a theory of liability, but the point of the statute is to be able to create a cause of action against the carrier.
But for you to prevail on your theory, then, given that the SCA has a built-in remedy, you're arguing basically that the SCA creates an expectation of privacy in call logs, which prior thereto did not exist under the case law.
Yes, that's right.
And that in order to deter that now constitutional violation, we should use the exclusionary rule.
Yes, and to Justice Gaziano's point, the important jump is use the constitutional tool of Article 14. And I do agree that to make that jump, that's a significant jump, and it requires...
Especially where the SCA already provides a remedy. I mean, I think that that's really the biggest hurdle you have.
Well, I agree with Justice Gaziano's problem that the point of the Article 14 remedy, this new remedy, is to deter police misconduct. I don't think that's the point of the SCA so much, because
Right,
you
but
get the cause of action.
You're using the SCA to piggyback in Article 14.
Right.
Right.
But that's, and if I would really urge the court to look carefully at a case, an Iowa case, State v. Wright. It's a trash case. And there's a local municipal ordinance that says the only people, if you put your trash out on the curb, the only people who can pick it up are licensed trash collectors. And we all know about the trash cases. You put your stuff out on the curb, it's on the curb. So if you're a drug dealer, the cops can come by and look at it. And in Iowa, they said, no, you can't do that. And the municipal ordinance said the only people who can look at it are licensed trash collectors, not look at it, pick it up and throw it away. As a matter of privacy, under the state constitution, the Iowa Supreme Court said, no, the police cannot go through your trash. Why? Because there's been this reasonable expectation of privacy created by this municipal ordinance. So I'm urging you to look at that. I'm not creating this out of whole cloth. This is an idea that I think has been recognized. But I take Justice Gaziano's point that it's important. The reason we would do this is to deter police misconduct.
Keep saying that, but
right.
Under Justice Gaziano's hypothetical, he's saying that say that he didn't act in bad faith. So how do you get there?
And he was just wrong.
I don't have a good answer to that question, Chief Justice. But I mean, but to be clear, I think it's clear that he was lying or acting in bad
Understood.
faith. Right. And if he wasn't lying or acting in bad faith, I don't have an answer.
Okay. Can I switch you for one last?
Yeah.
So I should know this, but Almanor, the basis of the killing there, it doesn't appear in the opinion, whether that was a drug deal gone bad or something different, which...
So Almanor, I'll try.
I'm looking at it myself, but I don't see...
There was I remember the sawed-off shotgun, but the court found that there was no there was an exigency.
Right, no, I understand
case.
we found an exigency there, and I understand it's a sawed-off shotgun, but you seem to stress that, okay, it's a drug dealer shot, there's no need to worry anymore. I'm just trying to remember, is Almanor also a drug dealer shot, and we were worried that the killer was on the loose?
Well, I'll quote from Almanor, the best I can do right now.
Mm-hmm.
This was not Almanor. This was not a case in which the threat posed by the suspect was limited to a particular victim for a particular purpose, such that the circumstances that led to the shooting dissipated thereafter. So, I mean, I don't know. I can go back and look, and I can give you a letter, but it sounds to me like it's not a drug deal gone bad. It sounds like, yeah, it sounds different.
Okay.
Okay?
Okay,
Thank you very much.
thank you. Okay, Attorney Campbell.
May it please the court, Julianne Campbell on behalf of the Commonwealth. I'm asking that this court affirm the defendant's conviction for the murder of Asia Pasquale. And if I could first, with the court's permission, I'll turn to sort of the legal question posed by my brother, because I do think that is...
Let me ask you, how do you distinguish Vinny? Because in my memory, at least, I haven't looked at it in a little bit, but my memory of Vinny was there was an administrative subpoena statute. The police were wrong, and we crafted a remedy based upon a violation of that statute. So I think that leads I think that leads to what Mr. Wood is saying, that whether or not it was bad faith, good faith, or whatever, there has to be some consequences to a violation of a statute that allows you to gather evidence, even if they are just call logs.
Sure, and so I apologize. I don't recall the statute specifically involved in Vinny, but what I would say here is that first, I'd suggest that this is a well-settled area of law in that a defendant or the Commonwealth is not obligated to get a warrant for call logs, because historically, and as recently as Commonwealth v. Gumkowski in 2021, there has not been a reasonable expectation of privacy in call logs specifically. That has never been recognized.
But there's a statute that allows for the gathering of this evidence, correct?
Yes.
As there was in Vinny and as there are in the SCA, or at least or these so-called D orders, right?
But that's correct. But what the defendant is asking this court to do is recognize a changing expectation of privacy based on police
Right, so let's call it a
conduct.
statutory violation, all right? So what's the remedy for a statutory violation?
Built into the SCA, it is a civil remedy, and had the investigators as they obtained the CSLI and ping data. They were not permitted to use that and did not use that because there is an expectation of privacy for that information. Call logs and CDRs are distinctly different, and I'd suggest the third-party doctrine does in fact apply, has historically applied, and has not been eviscerated with respect to call logs.
So what is the remedy for a lie by a police officer to get the information that
I would be happy
SCA
to,
would require?
I would be happy to answer that if indeed, first I'd suggest the remedy is at this juncture a civil remedy. However, the police did not lie here. There is no lie contained within that exigency form. That was a credibility determination. It's supported by the record here.
It wasn't particularly precise, though, right?
Certainly, and certainly T-Mobile is free to communicate with officers, as phone providers often do, in order to clarify. I point to the very minute detail that's included in that, and I'd suggest that it was not a lie. It was not in bad faith, and as the motion judge found, there was no motive to lie back then because the police didn't believe that they were doing anything wrong given the state of the law. And so, quite simply, both under
I don't understand, what's the explanation for the statement that the victim was speaking with a subscriber during the time of the murder?
That's not exactly what's written in the report.
What is?
If I could just have one moment.
Well, I can look at it.
But it's essentially that phone number was last contacted during the homicide.
And is that true?
The Commonwealth's position is that indeed the victim last called that person, being the defendant, prior to the homicide, and that the defendant then killed her.
Okay, so prior, not during. That's your position.
Well, certainly if someone was being murdered, I'd suggest they could not place a phone call.
Okay, so you're saying it literally this statement by the officer, just nobody would credit it because they're being killed?
Yes.
Okay.
Is there any detail in it? Because what I gather is that because it was a drug deal, this was inferentially the person that the victim met up with before they
Yes.
died, right? That being the main suspect, if it was the last
Yes.
person
That's part of how
they had transacted a drug deal with.
That is part of how the police grew suspicious of the defendant, among other pieces of evidence that they were going through in the span of 48 hours. There were certainly a lot of moving parts in this. And I would suggest that, especially where my brother represents, the police did lie. They did know the owner was alive. That's not true.
Was it accurate that the person on the other side of the phone was missing, could be in peril?
So, and I think Officer Washington's testimony reveals this, that at the time, they didn't know who the other person on the other end of the line was. They still had not recovered the victim's phone. They didn't know where the victim's phone was. The person who identified himself identified a made-up name of Brandyn Jackson. That may have been the owner. That may have been a murderer in possession of that phone. The police did not know, and I think the exigency form itself reveals the limited knowledge of what the police had at that juncture. And it was an ongoing emergency. The murder happened in the afternoon on the 29th. The exigency form was sent October 1st, 2 days later. In the middle of this, they had obtained the victim's phone records. They had begun calling people from her records. They had been conducting interviews. There were a lot of moving parts, and as part of that investigation, the police, in good faith and not lying, submitted an exigency form, which resulted in CSLI, ping data, and the call detail records.
There is one inaccuracy, right? Because they obtained the victim's phone records because they know her number, right?
Yes.
But the defendant isn't the last person. He's the second from the last. His number is the second from the last number, right? She calls somebody, she speaks to somebody else.
I don't want to misstate the record, Your Honor, and I candidly cannot.
Isn't the record clear that there was another phone call?
I'm not sure that there was a conversation that connected.
No, it wasn't, but there was, the defendant's number is not the last number called. There is actually another number called after the defendant.
I don't know if it was called or
Called or
incoming.
received.
Correct. There is another, that is true. However,
That somehow concealed in the representation to the phone company.
no, because the number that's being issued, the number at issue was last contacted it says during the homicide. I would suggest just prior to the homicide. So it's not that this was
That word last, again, we're quibbling over words, but I guess that's what we do.
At best, I would suggest that it's vague, but that does not intimate a lie. And I also would suggest that there is validity to it in that number, the one the records are being sought for, was last contacted prior to the homicide. And so it's in that reading that I think, again, where the police didn't have a motive to lie back then, it is hard to understand what that lie specifically would be when, at best, maybe it was vague, and I can concede that, but certainly not.
Help me just for a second, and I know I'm being obtuse here, but homicide investigation and number was last contacted during the murder. When we know that there's another phone call after that, how is that accurate?
The phone number being sought was last contacted during the murder, is my reading of it.
Okay, okay.
As opposed to, this was the last number calling the victim's phone.
I got you, okay.
But again, even, I'd suggest the facts don't support that there was a lie, but even if there was, the defendant does not, under the case law, under our federal law, or under Article 14, have a reasonable expectation of privacy in these third-party records.
Let's get to the second part then, because, so the cops get not only the call, but they get the CSLI and other stuff as well, right? So how do we separate out that?
This court did that in Gumkowski. And I would suggest that the Commonwealth, recognizing this.
You can do that on this record here.
Absolutely, Your Honor.
And let me add one other layer to it, which is, okay, the judge does that, but we also have an ineffective assistance claim here saying that maybe if there were better lawyering by the motion lawyer, that wouldn't have been done. So how do you deal with all of that?
So I would suggest that is not borne out, the ineffective assistance claim is simply not borne out by the record. And the reason for that is because the Commonwealth appropriately and voluntarily did not use records that it obtained prior to this case, this court's decisions in Augustine. So the Commonwealth, recognizing that those materials were obtained without a warrant, said we won't use them. Even though in 2012, we got them without a warrant, and that was lawful, we're not introducing them. We're not using them. The record doesn't suggest that they were used in the course of the investigation.
In order to do that, the motion judge she makes certain things go away, right? The graphic maps, which seem to be CSLI type of maps, or...
That's not true, and I would suggest that the judge's findings on that and the testimony that came out was that those maps were not used in the way that the defendant suggests they were. They simply were not, and that was not borne out by the evidence of the investigators. So I think the way that you take out the CSLI and ping data is the way that the Commonwealth did, recognizing it couldn't use it. So at the suppression hearing, that's suppressed because with the assent of the Commonwealth, all you're left is with the call detail records, which the state of the law was the same at the time of the suppression hearing. A defendant does not have a reasonable expectation of privacy in those records. And so those records were properly allowed to be admitted at trial. And at the motion for new trial, where the defendant cannot prove that the government lied, acted in bad faith, attempted to use this in some attempted to evade the law, given that posture where he doesn't have an expectation of privacy in these records held by third-party business, I'd suggest that is how this court can...
Is this the last sliver of third-party doctrine?
It's not.
I thought we had abrogated third-party doctrine.
So certainly third-party doctrine has been abrogated, but it's quite limited in where it's been abrogated, and that it's location information largely, which is incredibly intimate and is certainly not contemplated by the Fourth Amendment or our Constitution when it was written. And yet this court has applied an third-party doctrine all the way through until today, with the exception being location information, and that's an appropriate exception. But to eviscerate the entire doctrine where there are other lawful applications such as video surveillance, banking documents, there's all kinds of ways that a third-party doctrine comes into play, and There's simply no reason to eviscerate it here. And I'd suggest that the defendant's argument that the police can trigger someone's expectation of privacy is not the way that expectation of privacy
Well, I
is.
think the argument is a little more nuanced than the police can trigger it. It's that the SCA gives rise to an expectation of privacy in call logs that heretofore were not private.
So that may be what he's arguing. My understanding of the argument was that the SCA provides for disclosure when there is exigency, and if the police act without exigency or lie to get exigency, then that creates an expectation of privacy because it's outside the parameters of the SCA.
Right.
And that's dependent on another person's conduct to create an expectation of privacy that a defendant
Or
might
you could say
have.
it differently, to say instead, I think as the defendant is saying, that compliance with this statutory mechanism is the way to get this information. And absent compliance with that, that an individual has a reasonable expectation that the police will comply with those provisions of the SCA.
I think that's...
Why would that be an unreasonable change in the law?
It would not be unreasonable, but it does not equate to a constitutional provision that all people are guaranteed. That has never been recognized with respect to the SCA, and I suggest that this is not the case to do that with.
Why not?
Because of the third-party doctrine, and I think that's a compelling...
But the point is that it would further eviscerate that doctrine. That's the argument.
Yes, and I would suggest...
I'm not saying I buy it. I'm just saying I'm giving you the opportunity to respond, other than just to say from time immemorial we haven't done it.
Frankly, Your Honor, the courts say it better than I can with respect to the legitimacy and the value of the third-party doctrine, which is that to have an expectation of privacy in information that is being shared with someone else defeats a reasonable expectation of privacy in and of itself. That is
even when the statute gives some protection to the call logs.
Yes, because...
What case says that?
I don't have a case off the top of my head that explains that a statutory provision does not create a constitutional protection. I don't have a case for that, Your Honor.
When you get this, when you file for this stuff, you get not only the call logs, you also can get the constitutionally protected information.
You can limit it. I mean, now we would limit that with an administrative subpoena.
At the time, they got everything, right?
Again, prior to this court's decision in Augustine in 2012, they did get everything. And there have been cases, as I said, Gumkowski, the very same scenario was...
So I guess you could argue that, okay, so the statute provides a remedy, and then when you have a constitutional violation on top of it...
Correct.
Then you hit then you get the constitutional protections.
That's correct.
But if you're... For the call logs themselves, they don't rise to that level.
That's correct, and that is why the SCA provides for a civil remedy. Yeah. Seeing no further questions, I'm happy to rest on my brief.